Okay, thank you. Um, so I am the moderator. My name is Tom Dahdouh. I'm an attorney at the Federal Trade Commission. Um, just want to start off our wonderful panel on legal issues. But just to kick it off, I do want to mention one important thing. While I do work at the FTC, nothing I say reflects in any way the views of the FTC, the chair, any commissioner, or anyone at the FTC in any way. So with that, I did want to jump in and introduce our fine panelists. We've got Professor Christopher Leslie, who's appearing virtually along with me. Let me tell you a little bit about him. He is Chancellor's Professor of Law at the University of California, Irvine School of Law. He received his JD from Berkeley, his MPP from the Kennedy School, and his BA from UCLA. He has been a visiting professor at Stanford, NYU, and Texas. He's authored the Antitrust Law and Intellectual Property Rights book. He co-authors the IP and Antitrust and Analysis of Antitrust Principles Applied to Intellectual Property Law book. And he's also a co-author of Antitrust Law, Policy, and Procedure. He has published over 50 scholarly articles throughout many different law reviews. Next, in person, is Karissa Kang. She is a 1L at Yale Law School. At Yale, she serves as managing editor of the Yale Law and Policy Review. She also serves as a research assistant to two professors, Robert Post and Yair Listokin, and Fiona Scott Morton. She's currently co-authoring an article with Professor Scott Morton and fellow Yale Law student Cart Candela entitled, "Do We Need a New Sherman Act? To what end? By what means? For whose benefits?" Good questions. Next is Matt Summers, who is currently law clerk for Judge Saris on the Massachusetts Federal Court bench. During law school, he founded the Harvard Law School Antitrust Association. He was on President Biden's antitrust policy team for the 2020 general election. His antitrust-related publications include Facebook Isn't Free in Behavioral Public Policy and Rebuilding Antitrust Amidst Forced Arbitration in the Harvard Civil Rights, Civil Liberties Law Review. Last but not least is Kate Conlow. She is a fifth-generation Iowan, a 2L at the University of Iowa College of Law, and the editor-in-chief of the Iowa Law Review. Kate is also a student attorney at Iowa's Federal Criminal Defense Clinic and founded the University of Iowa Prison Writing Project. Her scholarly and professional work focuses on antitrust. She was a 2021 ABA Steiger Fellow, is currently a participant in Yale's Thurman Arnold Project, and her note on Facebook's monopolization of the digital social advertising market is forthcoming next year. She graduated from Vassar College in 2009, and prior to attending law school was a journalist and editor for over a decade. Most recently, she served as the managing editor of the literary journal, The Iowa Review. So before I turn it over to Professor Leslie, I did just want to say a couple of things about the big picture legal issue of competition in food markets. In the statutory scheme Congress came up with when they passed the Packers and Stockyards Act in 1921, the USDA, the FTC, and DOJ have various roles to play in addressing competition concerns and mergers in agricultural markets. Mergers are reviewed by either DOJ or the FTC, and clearance is granted depending on each agency's expertise and resources at the time. With respect to antitrust matters not involving a merger, Commission FTC jurisdiction is limited by statute primarily to the retail segment of the food industry, that is, to pricing and other terms of trade between wholesalers and retailers and the consuming public. Regarding non-retail facets of meatpacking and farming industries, such as the interactions between farmers or ranchers and meatpacking companies or processors, the Commission exercises jurisdiction only at the request of, or in limited circumstances with permission from, the Secretary of Agriculture. All three agencies have memoranda of understanding and work closely on competition issues in these markets. So with that broad overview, I did want to give it to Professor Leslie, who has some slides that he's going to put up now.
Thank you to the organizers for inviting me. I'm looking forward to this discussion. So for millions of people, the ability to purchase and consume affordable, healthy food is a function of their access to supermarkets and to full-service grocery stores. Unfortunately, supermarkets are disappearing across America, leaving behind food deserts in their wake. Numbered at over 6,500 food deserts, these deserts exist in every region of the country. Studies estimate that between 23 million and 30 million Americans currently live in food deserts, which are defined by access to supermarkets. The most common definitions include variables for both distance and income. So for example, in urban areas, the USDA defines a low-income area as a food desert if at least 1/3 of its residents live more than 1 mile from the nearest supermarket. Supermarkets are critical for getting affordable food to most consumers. Because of their economies of scale and scope, as well as their buying power with respect to wholesalers and distributors, supermarket chains can offer lower prices. Consequently, when independent grocers even exist to serve urban consumers, these stores typically charge 10 to 60% higher prices than chain supermarkets. Convenience stores, which often don't even have fresh fruit and vegetables, charge even more for their products. This absence of supermarket chains significantly increases the grocery bills for households in poor neighborhoods, especially for healthy food. The poorest people pay the highest prices, which makes it even harder for them to eat healthy fruit and vegetables and produce. Ultimately, due to the lack of supermarkets in their neighborhoods, the poor in America pay more money for less nutritious food. My research asks, why do some neighborhoods have supermarkets and others don't? An economist might say, well, it's because of market forces, but that's not accurate. At the dawn of the suburban era, many supermarkets closed their downtown storefronts and relocated to the suburbs. If market forces had been allowed to play out, new supermarkets would have moved into their abandoned locations. But that didn't happen. This supermarket exodus without replacement left many inner city neighborhoods with few or no full-service grocery stores, often for decades. So why didn't the market forces work? Well, supermarkets require a large footprint, both inside and outside of the store. The indoors must be able to accommodate several distinct departments and have sufficiently wide aisles to connect the various departments. Outside, in addition to any parking lot, a large supermarket requires significant space for unloading delivery trucks. The dearth of appropriate space in many urban centers is one of the greatest barriers to opening a new supermarket in an inner city neighborhood. The most obvious site for a new supermarket is the old location that the exiting supermarket left behind. But this location is often legally foreclosed to new competitors for reasons having nothing to do with market forces or efficiency. When supermarket chains and sometimes smaller grocers sell their old stores, they will frequently add a covenant to the property that precludes that site from being used to sell food for periods of years or decades. Such covenants are common. Walmart alone has imposed hundreds of them on their former sites. This slide presents an example of one of Walmart's anti-grocery covenants that prevented food from being sold on the land for 50 years. Safeway too has a reputation for using these covenants with abandon. But non-chain grocery stores also use them. And in some smaller communities, independent grocers will sell their grocery stores and put an anti-grocery covenant onto the land that prevents food from being sold from that. These anti-grocery covenants can help create or prolong food deserts. For example, a supermarket operator in New Brunswick, New Jersey, transformed the city's downtown into a food desert by closing its downtown location and imposing a 40-year anti-grocery covenant, despite the fact that most residents didn't have cars and there was no other supermarket in walking distance to their homes. More recently, when Safeway closed its Greeley, Colorado location in 2014, it sold the property burdened by a 20-year anti-grocery covenant that left 33,000 residents of the city's downtown without access to a grocery store. Supermarkets employ these anti-grocery covenants to force customers of their former stores to drive to the supermarket chain's other stores, such as those in the suburbs. The supermarket chain can maximize its profits by blocking any new grocer from using the chain's old storefront to sell food. Those former customers with cars will endure the hassle of driving to get their groceries, for example, by driving to the suburbs. But about half the residents of food deserts don't have either cars or access to public transportation that can get them to a supermarket. Those left behind are captives of a food desert, denied access to affordable, healthy food, and often living with chronic food insecurity. These residents of food deserts wind up with diets that have too much salt, too much sugar, too many calories, and too little nutritional value. The inevitable result is higher rates of heart disease, hypertension, and diabetes for people that live in food deserts. This in turn leads to a lower quality of life and a higher rate of premature death. The policy solution is straightforward. Anti-grocery covenants imposed by exiting supermarkets and grocers should be unenforceable as a matter of law. Such a change could be done either by judicial rulings or by legislative actions. Courts already have the authority to block the enforcement of anti-grocery covenants, and at least a few courts have done so. But for the most part, courts don't seem to understand the anti-competitive consequences and the real-world impacts of anti-grocery covenants. Judges tend to be cautious, more evolutionary than revolutionary, and not willing to strike down this category of covenant. By legislative action, cities and states could also ban grocery covenants, and to date, a couple of cities have done so. But this is pretty rare. Large grocery store chains hold disproportionate power over city councils. Safeway, for example, in Washington, D.C., threatened the city council if the city council moved to forbid enforcement of Safeway's anti-grocery covenants. Large supermarket chains can threaten to leave a jurisdiction and can simply leave their former grocery store location empty, which seems nonsensical, but it's a strategy that's so common, it has a name in the grocery industry. It's called going dark, just abandoning your store, leaving it empty, and letting nobody use it to sell groceries. Given the economic and political power of supermarket chains, state and local responses alone are probably insufficient to deal with anti-grocery covenants. It makes much more sense to have a nationwide policy against the enforcement of anti-grocery covenants. In theory, a federal agency, like Thomas's, could employ its rulemaking authority to promulgate a nationwide prohibition on the enforcement of anti-grocery covenants. This would be the single most effective way to prevent the artificial barrier to supermarkets and grocery stores opening up locations in food deserts. Ultimately, because food deserts have multiple causes, no single policy lever can remedy the problem. But one factor causing or prolonging food deserts in many communities is the presence of covenants that run with the land and prevent the most suitable space in a neighborhood from hosting a grocery store. A nationwide ban on anti-grocery covenants would help reach the goal of restoring supermarkets and full-service grocery stores to inner-city neighborhoods that are currently food deserts. Thank you.
And turning and continuing the whole discussion about covenants, Karissa Kang.
Can everyone hear me? All right. First, I'd like to start by thanking Austin, David, everyone else who made this conference happen. Thanks also to Professor Scott Morton, who encouraged me to submit my paper idea for this conference. And then also thank you to my friends who are here and who have put up with me obsessing over Stop and Shop for the past 6 months. I don't know how you guys are still here. So I find it somewhat ironic that I'm on the panel about legal issues because, as was stated in my bio, I'm a first year here at Yale Law School, and the extent of my antitrust law knowledge is I've taken half a semester of antitrust with George Priest. So I guess I'd like to start by saying I really have no disagreements with what Professor Leslie said right now. And what I'd like to talk to you today about is, I have no bones to pick with Professor Leslie, but rather zooming into a particular grocery chain that used the kind of deed restrictions that Professor Leslie just was analyzing. And that grocery chain is Stop and Shop. So really the story of how I got into this Stop and Shop thing, it starts right here in New Haven. So if you've spent any amount of time here in New Haven, you know there are like 1,000 pizza places, for example. But what you may not know is like, there's only one grocery store. There's only one full service national chain grocery store in all of New Haven, and that is Stop and Shop. And I have friends who they drive sometimes to other grocery stores out of town, but I don't have a car. So I just walk to Stop and Shop all the time. And so that has given me kind of an inside look at the kinds of people who frequent Stop and Shop, which, they tend to be people without cars too. They tend to have walked there. And then I also noticed that Stop and Shop here, it's not that great. Or it's not in great condition. And it's like I started wondering what's happening, and I'm coming from the South where we have a lot of different grocery stores, even within one suburban town. And so I did not understand what was happening. And so I started, as one does, I often Google search my questions to figure out if someone smarter than me has an answer. So I Google search something like, why does Connecticut have so few grocery stores? Why are they so bad? Something like that. And somehow I found one relevant piece of information on, obviously, one of the most trustworthy sources for this type of information, Reddit. And the thread was called something, it was my question essentially, what's wrong with Connecticut? Why do we not have more grocery stores? And people were commenting on the thread saying something like, they were saying, well, Stu Leonard's was gonna come into my town, but then Stop and Shop prevented them. And I was like, what does that mean? And another person was saying, oh my goodness, that happened in my town too. Trader Joe's was gonna come in, but Stop and Shop prevented them. I was like, what are these people talking about? How did Stop and Shop prevent these other chains from coming in? So I was a little bit incredulous about all of this. But I did a little bit more digging, and I found that the people on Reddit, they're kind of right in a way. And I don't know about the veracity of their particular towns because they didn't list them. But Stop and Shop does employ the kinds of deed restrictions that Professor Leslie was just talking about, where they will try to prevent competitors from moving in by either they will move out of a particular lot that was suitable for a grocery store to a place a couple miles away, and they'll put a deed restriction on that original land. Or if they see a plot of land that might be good for a grocery store, they'll purchase it, and same thing, they'll put a deed restriction on it so that no grocery store can move in there. So it's clear they're trying to block out competitors. And at first I was learning all of this information kind of in scattered pieces through news stories mostly. It was actually hard to find information about Stop and Shop in particular, but a bunch of local reporters had written about this topic, specifically with regard to Stop and Shop. And that's how I found maybe the most important instance of Stop and Shop's deed restriction tactic, which happened right here in Connecticut, in Stonington, Connecticut, where I think this is the only time when a state AG's office has ever gotten involved with grocery store deed restrictions like this. And the AG of Connecticut at that time, General Blumenthal, he got involved because the people of Stonington, requested his help, saying, hey, Stop and Shop moved out of this lot and it's been empty for a number of years now. It's driving business down in the plaza because foot traffic is down, things are not well. And it's interesting in the letter that the people of Stonington sent to General Blumenthal, they actually referenced a research paper produced by Dr. Cotterill right here. And you wrote this in, I think, 2003. So a while ago, detailing this exact tactic that Stop and Shop uses these deed restrictions in order to prevent competitors from moving in. But for some reason, I had not been able to find that until I read this letter from the people of Stonington. So somehow that had gotten buried, but you were writing about this exact issue. But despite the evidence that the people of Stonington brought to General Blumenthal, he responded saying essentially that his hands were tied, that these types of restrictions were not illegal, even if, maybe they're not great, or that they're having negative effects on the people of Stonington. And he was working, I think, within a sort of rule of reason framework. And so it makes sense in a way what he's saying. But as Professor Leslie said, that doesn't mean that normatively it should be right. There's no justification for these deed restrictions other than they're trying to keep competitors out. There is no pro-competitive justification for them. And so this does seem to be an instance where we shouldn't be fretting about defining geographic markets or proving evidence of anti-competitive effect when it seems just so abundantly clear that there's no other reason for these deed restrictions to exist. So regarding solutions too, here too, I would probably agree with Professor Leslie. I don't know that much about FTC rulemaking. I haven't learned that in my antitrust class, I guess. I do maybe I'm a little bit more optimistic about local ordinances than Professor Leslie is, just because I don't think that it's a sustainable long-term solution. I agree with him about that. But what I'm worried about is I look at New Haven, for example. I look at the Stop and Shop I go to every week, and I think to myself, if this Stop and Shop moved a couple of miles away and then placed a deed restriction on this land, where am I going to get my groceries? Well, I have friends with cars and we're students, so we're not doing all that much. But what about all the people who live here and who, they walk to Stop and Shop? How are they going to get to that new Stop and Shop? And then that lot's going to be empty. So for that reason, I feel a great sense of urgency, maybe because I see the Stop and Shop all the time, and I wonder what would happen to the people who use it here in the city of New Haven if the city or the FTC or whoever is making a rule against this deed restriction, if they don't act quickly. So I certainly feel that sense of urgency. I would say lastly too, on a slightly more meta note, I've been thinking throughout this whole conference about how every single idea that everyone has proposed today seems to be a real problem that we should do something about, as is the deed restriction problem. But it's funny to me that Dr. Carter already wrote about it 20 years ago. And if someone 20 years from now, some excited law student were presenting a paper saying, let's bring awareness to Stop and Shop using this tactic, I would be depressed if that were still happening 20 years from now. And so I don't know, right?
Yeah, we've been depressed for 20 years. It's nice you're here.
So I just think whatever solution is most appropriate, I just want something to happen. It has been a long time since people have, I think, adequately shown that this type of restriction is not okay and that it should be illegal. So whatever happens, I think that we should try to act quickly, and I think I'll leave it at that. Thank you.
Well, thanks so much, Karissa. I want to turn now to Matt Summers, who is going to be talking about an issue that my agency and DOJ focus on, and that is divestitures. When mergers happen in food retailing and the agencies come in to acquire divestitures or stop it, how does it work out? So Matt, you want to tell us how it works out?
Sure. And I'll do it with a story that starts with corporate sabotage and ends with giving power to the people. So hopefully that'll be interesting enough. To start with the sabotage angle, back in 2015, Safeway was merging with Albertsons. These are two large national grocery chains. And the FTC took a look at it. Oh, closer. There we go. Am I, this is good? Great, cool. So anyway, Safeway, Albertsons merging. This is back in 2015. The FTC takes a look, says, overall, this won't harm competition too much as long as they divest 168 stores. So they can merge, but they have to kick off these 168 stores to other grocery chains to maintain competition in those areas. But as they're about to merge and they're about to divest these stores, Safeway Albertsons starts migrating customers away from those stores just before they sell it. They start removing like actual fixtures from the grocery stores. They start understocking staple goods, and I think somewhat comically overstocking perishables in those stores just before they hand them off. It's like putting a bunch of a few dozen eggs in the trunk of your car before you sell it to a friend and then not mentioning it. They provided misleading pricing information so that as soon as Hagen took over the store, this is another grocery chain, it would look like it was massively overcharging. And customers would be like, no, I'm not gonna go here. I'm gonna go to the Safeway Albertsons store elsewhere. So as they're doing this and stopping to do routine maintenance and all this stuff, they sell it over. Hagen is like, great, we got all these grocery stores. It's gonna be a blast. And then all of a sudden starts realizing these problems. They sue Safeway Albertsons and get a $6 million settlement. But that's not enough to stop Hagen from going bankrupt. Hagen goes bankrupt. And guess who wants to buy back all the stores? Turns out Safeway and Albertsons decided that they could buy back about a dozen of those stores that they had sabotaged, forced the other company into bankruptcy, and then gets to buy back the stores with the approval of the FTC at the time. So what's the problem here? The problem is that in the consent order that was signed by Safeway Albertsons and issued by the FTC, there was a requirement that Safeway Albertsons wouldn't be able to buy back the stores, at least not without like FTC approval, et cetera. But as you can imagine, FTC and DOJ, when they put out all of these consent orders, often hundreds of them per year, these consent orders are the way that most antitrust enforcement happens in America. Instead of bringing a case all the way to trial, trying to block a merger wholesale, the agencies put out these consent orders. They force divestitures, meaning that they can maintain competition by selling off some of the assets. But it's often very challenging to enforce these consent orders. They have some mechanisms, like the companies have to submit compliance reports, they have to give the agencies access to records, and the agencies can file contempt charges if they violate the consent orders. Those contempt charges can be pretty substantial if the agencies are willing to go to court and bring them. For Safeway Albertsons, for example, violations of the consent order could get the FTC and DOJ $16,000 per day of violation. So as you can imagine, that really adds up. Looking backwards to understand how this works, back in the 90s, Schnucks Market merged with National Holdings, Inc., again, two grocery chains. They divested 24 stores, but again, sabotage ensued. So they stopped cleaning and restocking the shelves. They removed equipment. They delisted the phone numbers from local registries so that people couldn't find the grocery stores anymore. And the FTC said, yeah, that's not going to work, and got over $5 million in today's dollars settlement based on those contempt charges. So now let's move to bringing power to the people. Because while it's great that FTC and DOJ can take these actions, they can file contempt charges, and they can force the merging parties to comply with the consent orders, these agencies are dramatically under-resourced. They have hundreds of mergers coming at them that they're evaluating anew, and it's really challenging to go back through your books and look at every single consent order that you've issued over the past decades to make sure that no one's violating them. So my paper proposes introducing a private right of action so that individuals and companies can bring charges for companies that have violated the consent orders. The basic idea here is instead of just making DOJ and FTC the police for all of this, individual competitors, for example, or consumer groups can identify when there's been a violation, and they can take the companies to court. So there's actually five, let's go with five, specific proposals in this paper that can be grouped in different ways. The first one is in the consent order themselves. Instead of just saying, if you violate this, we can take you to court, you can name third-party beneficiaries. You can say the public at large are the beneficiary of this agreement, and therefore they can bring charges if the agreement is violated. Second, you can do something like assigning the contract rights. So instead of FTC or DOJ getting the $16,000 penalties per day, the FTC and DOJ can assign that out to third parties. Third, the agencies could employ private law firms or use the litigating power of private law firms to bring these charges if they feel that the consent order has been violated. Fourth, if Congress is on board, we can do legislative changes in, I think, a fairly bipartisan fashion, because in general, people like these kinds of consent orders to be followed. It's a basic enforcement priority to make sure that after you've put down a rule, that people actually comply with it. Fifth, you can change the process for the FTC when the FTC has an objection to a consent order, or if someone violates a consent order. Right now, in the Safeway Albertsons example, when the companies wanted to buy back the stores they had divested, the FTC looked at it and said, well, it seems like Hagen's going bankrupt. There probably won't be too bad of an anti-competitive effect here. And so they signed off on Safeway Albertsons buying it back. It's kind of a complication in the story that I'm happy to talk through in questions. But I think one solution would be to change it so that it's not just the FTC and DOJ that are approving what I think you could fairly consider to be going back on the deal. You could make the states are parties to these actions, or you could say that, for example, if any state objects, not just the FTC or DOJ, then either they'll take a closer look or they'll prevent them from buying back the stores that they had just sold off. So quickly on the benefits of this plan, the first is pretty obvious, that if you have more people looking out for violations that have better information because they're actually in the affected industry, they have better incentives for keeping a really close eye on whether there are violations, you're just going to get better enforcement, which means that instead of violating these consent orders, companies are going to be forced to comply with them. But I think the most interesting angle here is that you actually get better ex-ante incentives also. That means that when FTC and DOJ are considering what restrictions to put into consent orders, right now I think there's a caution of being too ambitious, because if you put too many restrictions into the consent orders, who's going to have to enforce that? You're adding to your own to-do list later to keep an eye on all of these things over, basically perpetuity. But if you know that there's going to be other people looking out for it and other people that can bring contempt charges, it makes it much easier for you to be more ambitious in the first instance and ultimately better protect consumers. Thanks.
All right, thank you very much, Matt. I want to turn now to Kate Conlow and to a slightly different issue, conflicts of interest, an issue actually near and dear to my heart. But Kate, you want to take it on?
Yeah, thanks, Tom, and thanks, Austin and David and the Thurman Arnold Project, and also Austin's mom. And also, I want to thank Karissa. I went to undergrad in a Stop and Shop town, so I've been having lots of lovely flashbacks to walking to and from Stop and Shop with all my groceries, so thanks. So I'm really excited to be talking about this topic because it kind of blends my antitrust interests with my former career of publishing. So I'm going to be talking about non-disclosure of conflict of interest in academic, agricultural, economic publishing. And these issues extend beyond agricultural economics, but I'm going to be focusing on ag. So first I'm going to talk about the issue, give a background of the role of that play in policy making and the law for those who aren't aware, and then discussing non-disclosure in academic publishing. And then I'll give an example, and then I will present solutions. So I think that a lot of this audience probably is aware that economists are very involved in antitrust, competition, market condition issues in agriculture and food retail. And agricultural academic economists often provide guidance and expertise to the USDA. And also the USDA will cite these economists' scholarly articles in their own research. An example of the USDA working with academic agricultural economists, in 2020, Congress called on the USDA to examine concentration in the US beef market. And so in this letter I have up here from former Secretary of Agriculture, Sonny Perdue, members of the House, the former USDA secretary, the members of the House Committee on Agriculture asked the department to look into the concentration in the beef market, as well as fluctuating beef prices and the big four beef meat packers. So to write the report, the USDA's Office of the Chief Economist commissioned the Agriculture and Food Policy Center at Texas A&M University to research and compile a study that look into the issues surrounding fed cattle pricing. So here's the report. And so from there, Texas A&M contracted with academic agricultural economists from land-grant public universities to write 10 papers to provide guidance to the USDA. And so here's the report, the US beef supply chain issues and challenges. So I'll return to that, but that's just to give you a little bit of a background of kind of the impact that economists can have on policy and law. Academic economists often serve as consultants or expert witnesses in addition to their faculty appointments. One of the authors from the cattle market report wrote in a recent article, a perk of academic employment for agricultural economists is the ability to earn additional income from non-university entities by consulting. And I'm not critiquing the consulting work. I'm just talking about the issue that this consulting happens, and a lot of times there just isn't disclosure in published work of these conflicts of interest. So why are conflicts of interest problematic? This seems maybe seems obvious, but some people push back that it isn't an issue. Research showed that conflicts of interest distort outcomes and can compromise the integrity of research. This study has, this has been referred to as the funding effect. And one study showed that research funded by private companies compared to independent nonprofit and government sources as controls tended to produce outcomes consistent with the financial interests of those companies. So there isn't a standard rule or obligation for economists to disclose conflicts of interest within the industry, like there is with, for example, accountants or lawyers. And likewise, in publications in academic journals, they have varying degrees of disclosure requirements. So in 2012, responding to critique coming from this documentary called The Inside Job, the American Economic Association, which has 9 journals, they instituted for the first time a disclosure requirement of conflicts of interest. And then shortly thereafter, the Agriculture and Applied Economics Association, which has 6 journals, adopted a similar disclosure requirement. Today, it is unclear kind of how much the agriculture and applied economics associations journals actually enforce those disclosures. If they do, I was unable to find them. And likewise, the American Economic Associations are behind a paywall. And then you have to download a zip file and open it. So they aren't very forthcoming with the disclosures. And additionally, I could find no USDA policy requiring disclosures of conflicts of interest for economists, and neither could my research librarian. So moving back to the USDA cattle market report, there were no conflict of interest disclosures in this report. And I know that there are some conflict of interest because I dug and found a couple. A lot of times, conflicts of interest are not disclosed necessarily on a professor's faculty page or even on their CVs. But I did find that one economist at Colorado State who authored another look at alternative marketing arrangement use by the cattle and beef industry. He works closely with the National Cattlemen's Beef Association, and the NCBA has a great interest in preserving AMAs, and they represent meatpacking interests. Additionally, another agricultural economist at Kansas State, a co-author of Enhancing Supply Chain Coordination Through Marketing Agreements, Incentives, Impacts, and Implications, had current or past contractual work of his includes industry associations and private companies, the Cattlemen's Beef Board, Keystone Foods, which is McDonald's beef, pork, and chicken supplier, CAFO's Best, and the National Pork Board. And then another example, this economist at Purdue named Jason Lusk, he was asked to testify in Congress in July 2021 on the state of the beef supply chain, and the bio did not talk about any sort of conflicts of interest, though I was able to find that he consults or gives presentations for Beef Cattle Research Fund, Corn Refiners Association, National Pork Board, National Pork Producers Council, and more. So solutions. So I really think that for scholarly publications, these conflicts of interest need to be more forthcoming. They shouldn't be buried behind a paywall, and they need to be enforced. And I mean, especially because economists just have so much influence on policy and lawmaking, it's just really important to have those out there. Similarly, I found interviews with mainstream media like the New York Times and industry publications that also did not include these conflicts of interest disclosure. And finally, I really think the USDA needs to have a formal disclosure of interest, conflict of interest, through a codified federal regulation. The Department of Health and Human Services, their public health service has one. It's a great template, and it would be a good place to start. And I really think these ethical standards will bolster the integrity of the agency and ensure private interests are not being promoted through purportedly neutral research. And I would also encourage the agricultural academic economists to adopt ethical standards to disclose these conflicts of interest. They have so much, again, they have so much influence, and I think that why hide that, and it'll just be helpful to everyone. So thank you.